Welcome to the digital lecture series of FU Best, the European Studies program of Freie Universität, Berlin. In 15 sessions, we will offer you a broad overview of FU Best's academic course offerings. You can choose from 12 subject course lectures representing a wide range of disciplines and 3 live sessions on German language and culture. Our series is divided into 4 themes relevant to European studies in Germany and Berlin today. Each will be dealt with by a group of FU Best instructors from the perspectives of their particular disciplines or German language levels. Part 1 provides some background to modern shapes of Berlin, Germany and Europe and asks how history influences the present. As examples, we will look at physical appearance in Berlin's architecture, the psychological and sociological roots of complicity in the atrocities of the Third Reich, how Jewish culture and writing has reclaimed a place in German society, and the role of legal thought in the rebuilding of Europe in the 20th century. All sessions will offer you insights into our instructors' semester-long regular courses within the FU Best program and the way in which they integrate Berlin as a historical and cultural location. We hope you enjoy the online program we have assembled for you. For more details about the lecture series and our regular on-site FU Best program, visit our website later. You will also find additional information at the end of this lecture. With that, enjoy the following session and see you soon in Berlin.
Hello everyone and welcome to today's online program. My name is Max Wagner and today I'm going to talk to you about how states and how societies drew lessons from the past and what role the law played in the peaceful reconstruction of Europe after the transformations of the 20th and early 21st century. Before we'll get started, let me briefly introduce myself. I studied law in Mainz, in Berlin and in Istanbul, and I obtained a degree from Universität. I majored in law, but I specialized in legal history, an interest that I have also pursued professionally. I worked for various institutions, most notably the German Parliament and the Max Planck Institute for Legal History in Frankfurt am Main. Aside from teaching European legal traditions here at FU Best, I also tutor constitutional law at the European University in Frankfurt an der Oder. For the next 30 minutes or so, I am going to talk to you about European legal traditions in general, about what to expect from this class and why you should study European legal traditions right here in the German capital. I am also going to showcase some of the topics and tropes we're going to debate in class. Let's go get to work. What is European legal traditions? In my opinion, European legal traditions is an unorthodox and creative approach to European legal history. It focuses on, but is not necessarily limited to, the European context. Together, we will have a look at the creation, establishment and development of what could be called the Western legal tradition. We will unearth its historical roots and take a glimpse at its future challenges, most notably climate change and social justice. In this class, you'll learn how to define, differentiate, and how to situate the Western legal tradition within Europe's diverse cultures, economies, and histories. First, we're going to go all the way back and have a look at the mythological origins of European law in ancient Rome. We are then going to trace those origins all the way through nearly 2,500 years of European legal evolution and analyze how it branched into 2 distinct traditions: the continent's civil law tradition on the one hand and Britain's common law tradition on the other. We will look at Germany, at France, Spain, England, and of course the US in comparative terms. And we are going to look at how a human rights discourse could emerge amidst the discovery of the so-called New World, against the backdrop of European colonialism. Finally, we will make a stop in Brussels and look at the EU and Europe's other supranational institutions and their attempts at piecing together a shared European legal identity from tradition. The overarching learning objective of this class is to paint a vivid picture of Europe's past and present, of its diverse people and their various attempts to order their societies in a just and meaningful way. The overarching question that we're trying to answer, or actually that we're trying to pose from a variety of different points, but not necessarily try to answer, is what is law and why should we care? Now, this question has been brought forward in a much more elaborate version by renowned British legal philosopher H.L.A. Hart as early as 1961. In 1961, Hart wrote, "Plainly, the best course is to defer giving any answer to the question, to the query, what is law, until we have found out what it is about law that has in fact puzzled these who have asked or attempted to answer it, even though their familiarity with the law and their ability to recognize examples are beyond question." What more do they want to know, and why do they want to know it? Now, why should anybody come to Berlin to study, say, the Roman roots of European law? Why not go to Bologna, where these roots have been unearthed quite literally? If you're interested in human rights, why not go to Salamanca, where the European human rights idea was first conceived? Why not go to Brussels, the center of European legal evolution? The answer is simple. Because in Berlin it all comes together. Or more precisely, because it all came together and fell apart again. Let me ask you a question. What is the first image that comes to your mind when you think about Berlin and its diverse history? It's the Berlin Wall, isn't it? And rightly so. When I pose this question to my students and colleagues, an overwhelming majority usually answers the Berlin Wall. For almost 40 years, from summer 1961 till autumn 1989, Berlin was divided by a concrete barrier wall. Berlin was an amputated capital, a symbol of division, with barbed wire running through its very heart, separating east and west. Since about 30 years, however, the scene is fundamentally changed. The German capital, Germany, and Europe are united once more. Today, Berlin is no longer a symbol of division, but a symbol of diversity in unity. It once more joined the ranks of the thriving and vibrant European capitals. Berlin today is a symbol of division, unity, and diversity, a city full of rich history and stark contrast, of law and of lawlessness. Right here in Berlin, the very first German democracy, the Weimar Republic, blossomed. It was here that liberal democracy was defeated and Hitler rose to power, and it was here that Hitler in turn faced his downfall and democracy was re-established, at least in one part of the city. It was in Berlin that the Iron Curtain fell, and it was here in November 1989 that it was lifted once more, uniting Europe once and hopefully for all. One of the main themes that we're going to explore throughout this class is how the law has divided and united Europe and its people time and again, and I firmly believe that there's no better place than Berlin to study exactly that. The diverse history of the city has left its mark on Berlin. It can be seen and it can be felt in every step that you take when you walk through it, and I think that in Berlin you cannot only study European legal traditions, but you can experience them. Now, one of the most pressing historical questions of our time, if there is such a thing as a pressing historical question, anyway, one of the questions that we're trying to answer in class is, how could it have happened? How was it possible that a country such as Germany, with a relatively high standard of living, with a liberal tradition and a democratic constitution, turned fascist seemingly overnight? How could Germany start yet another world war and commit unprecedented atrocities, a genocide, in the very heart of the old world? Obviously, there is no simple answer to that question. Any effort requires time and tedious research. Of course, you can always try and work things out on your own from home now more than ever. During the pandemic, you might, for example, just want to check out the available documentaries right here on YouTube, and I strongly advise you do that. However, Nothing will replace the possibilities and opportunity you're going to have in Berlin, you are going to have inside. In Berlin, you won't only have access to numerous libraries that are stuffed with a wide array of literature on the subject matter, dozens of archives and museums that are dealing with German history in general or with National Socialism in particular. You might also visit nearby concentration camp Sachsenhausen that is only an hour away. You can visit the Holocaust Memorial and of course the Jewish or Germany's National Museum. Or, if you want to take it one step further, you just might take a stroll through the very streets where it all happened and discover Berlin as a living history museum, which is exactly what we're going to do in class. One of the first exercises we'll do is to do exactly that. We're going to take a walk through the streets of Berlin, more precisely through the Bavarian district in Schöneberg in the southwest of the city. Here, Berlin-based artists put up one of the most harrowing Jewish memorial sites in Berlin, a public art installation called Places of Remembrance or Orte des Erinnerns. The memorial itself consists of 80 images and texts, as you can see on the slides, that are dispersed throughout the neighborhood, illustrating some of the Nazis' most disturbing anti-Semitic legislation. Jews were shut off from ordinary life in numerous ways in Nazi Germany. They were banned from playgrounds, for example, from the use of the public beach. They were forbidden to join choral groups or buy newspapers and magazines. They were even forbidden to purchase even the simplest everyday items like bread, milk, or shaving cream. The signs and images that are put up in Schöneberg, they force passers-by to stop for a moment, to consider and remember the neglected history of a former Jewish neighborhood, the neighborhood where such famous people such as Albert Einstein, Hannah Arendt or Billy Wilder used to live. Places of remembrance provide a prime example of how the law was instrumentalized by the governing party of a single state to systematically divide its people and to deprive them of their jobs, their civil liberties, and eventually lives, day by day, step by step. And it provides you a singular opportunity to study how this legislation affected everyday lives of ordinary people here on site. Generally speaking, the Nazis had nothing but disdain for the rule of law. In the self-proclaimed Third Reich, laws and jurists were seen as impediment to the movement and to the movement's hunger for absolute power. Naturally, any procedure aimed at conflict resolution was fundamentally incompatible with a racially homogeneous ethno-state that did not allow for any kind of conflict to arise or that wanted to resolve all kinds of conflict by the laws of the jungle. There is only one law in the world, Hitler said in 1928, and that law resides in one's own strength. 14 years later, in 1942, he added, jurists are either inherently defective or they will most certainly become so in the course of their lives. Now there are various examples to illustrate what this means or what this meant for the legal practice in 1930s Germany. When I think about the Nazis' complicated relationship with the rule of law, however, I like to think of one specific trial, the trial of Adolf Hitler. Hitler was on trial in 1924 for his attempt to overthrow and take over the German government. On November 8, in 1923, he and his followers had staged a coup in Munich, the infamous beer hall putsch. They tried to copy Mussolini's March on Rome, but miserably failed to do so, in part, by the way, because the federal state government of Bavaria, who was in on the plot, withdrew their support in the last minute. The failed putsch and the subsequent trial for high treason launched Hitler into popularity. When he first appeared before court, he gave a 4-hour opening speech where he meticulously explained his political ambitions. He claimed that the federal government in Berlin had betrayed the Reich, had betrayed the German people by surrendering the World War and by signing the Versailles Treaty, and he argued that there is no such thing as treachery, as treason against a treacherous government. Hitler found open ears because sentiments such as that were not uncommon during the Weimar era. Quite the opposite. They were wildly popular in conservative or monarchist circles, including, unfortunately, the very court that put Hitler on trial. "A tremendous guy, this Hitler," one of the judges exclaimed during the trial. Ultimately, Hitler was convicted. He was, however, only sentenced to a lenient sentence of 5 years in prison, the minimum sentence, in part because of the court's sympathy. He was later granted parole after only 8 months, which he used to dictate his book My Struggle, Mein Kampf. Under a strained interpretation of the law, he was not banished from Germany, despite holding the Austrian citizenship at the time, despite having committed high treason in a foreign country, a political crime. Let that sink in for a moment. If Hitler had only served his time, the full 5 years, in 1924, he wouldn't have been released from prison before the Great Depression. What's more, if the law had been applied correctly, if the law had been applied as written, Hitler would have been banished from Germany. Either way, he wouldn't have been able to take power, not in that short time anyway. It was the conservative Bavarian judicial system that bent the law back in the day and that backed Hitler at that crucial moment in time, and it was the contempt for law, for the rule of law, and for democracy that made Hitler possible later on, that made Hitler possible in the first place. Hitler himself learned a valuable lesson from the failed putsch. Any attempt to overthrow the state with sheer force would bring forth a military response. Hence, he changed his tactics. After the beer hall putsch, Hitler committed to taking advantage of the Weimar democracy to subvert the system from within. He utilized history as he had done in his 4-hour opening speech in court, and he employed a legalist rhetoric, ultimately culminating in the assertion that the National Socialist seizure of power was nothing less than a legal revolution. When the economic crisis of 1929 hit the continent, when the Wall Street crashed, it hit pretty hard, and it led to an erosion of democracy in Germany. The fragmented Weimar party system could no longer produce stable majorities. Changing chancellors governed Germany in quick succession, and they governed Germany by emergency decrees. The last German government, at least the last democratic government, finally consisted of conservative aristocrats who did not see the National Socialist threat, or who did not see the National Socialists as a threat. They refused to bend the party and its paramilitary organizations, and were convinced that they could tame Hitler, or more precisely, that the office and the dignity of this office would tame Hitler once he came into power. Interestingly, the Nazis had lost 35 seats in the November 1932 election. They had lost their momentum, but however, Hitler was still appointed chancellor with the support of his conservative supporters. From there on, everything went down quickly. Following the Reichstagsfire in 1933, the Nazis immediately began to suspend civil liberties. The so-called Enabling Act of March 1933 gave Hitler nearly absolute power, the freedom to act without parliamentary consent. Since the Nazis' disdain for certainty and predictability kept them from passing an actual constitution during their reign of terror, both the Enabling Act and the Reichstag Fire Decree have been called the Constitution of the Third Reich by Jewish émigré Ernst Fraenkel. In addition to the procedures prescribed by the Constitution, laws could now be enacted by the government of the Reich and deviate from the Constitution. It was permissible to restrict the rights of personal freedoms. Warrants for house searches, for example, now were permissible beyond the legal limits otherwise prescribed. These two laws were the legal revolution that the Nazis have dreamed of. They gave the fascist terror a touch of legality and increased the acceptance among the general population, because of course there were lots of people who were disagreeing with fascism or even opposing fascists, but there were significantly fewer who wanted to get in conflict with the law or who would oppose the rule of law, and there were hardly any people who were willing to breach the law in order to fight fascism and the National Socialists. Two of the most notable exceptions from the Nazi disdain for law were the so-called laws for the restoration of the professional civil service and the Nuremberg laws. Both excluded non-Aryan and political opponents from civil society, and both only thinly veiled the terror they legalized. Jews and members of the Communist Party could no longer serve as teachers, as professors, or as judges, for example. Jews were stripped of their citizenship rights. Marriages and extramarital intercourse between so-called Jews and so-called Germans were prohibited and punished by law. As you can see, it didn't start with the gas chambers, but with a legal segregation and the denial of basic social and political rights, as is, for example, tangible in Schöneberg's Places of Remembrance. If the Nazis did not change the old laws all that much, then how was it possible for them to rule as smoothly as they did, with the existing laws, with the constitution even that was passed under a democracy? This question has preoccupied legal historians since the 1960s. They identified essentially two components that allowed the National Socialists to transform the democratic law and to use it as an instrument of oppression, a combination of a strategic employment or personnel policy and a revaluation of all values. At the beginning of the 1930s, more than half of all chairs in Germany were newly stuffed. 1/3 of all law professors were dismissed. Vague ideas of leadership or of an imagined national community, of Führertum and Volksgemeinschaft, or even more bluntly, of the people's sentiment, of Volksempfinden, became new sources of legal interpretation. It is quite revealing how the legal practice was imagined, or rather reimagined, by the scholars of the time. Jurisprudence took an irrational turn. Let me give you some examples. I'm going to quote from the publications of renowned Nazi jurists of the time. Laws cannot be computed by reason alone, but rather has to be felt, it has to be experienced. Blood must become Geist, Geist must become blood, or in each and every word we utter, the very blood of the people thinks. Now all of this is powerful stuff, right? It's pretty emotional and evocative. However, none of those emotive formulas have any real meaning. They apply to feelings, to irrational feelings that reside in all of us. The true and gruesome meaning cannot be found in theory or in the writings of these jurists, but rather arises in practice. They served as justifications, as empty formulas for an unlimited and unconstrained reinterpretation of the existing laws. No rule, let alone a rule of law, but a permanent state of exception formed the basis for the National Socialist policy. A prime example how this interacted, how the extra-legal terror that supported the Nazi system merged with the laws is the Night of the Long Knives. In 1934, Hitler issued a series of extrajudicial killings intended to consolidate his power, and he had at least 85 people killed. Hitler justified the purge later on in a nationally broadcast speech, and he retroactively legalized the murders. In a move unparalleled in legal history, he passed a law that had only one sentence and declared the measures to be lawful acts of self-defense. The National Socialists cultivated an instrumental view of the law. The law was no more than a means to an end. New laws were passed to legalize National Socialist measures. The old laws were reinterpreted so as not to be a burden for the new rulers. The National Socialist contempt for law ultimately eliminated the law as a control mechanism. The Nazis enacted relatively few but all the more important laws, the Enabling Act, for example, or the Nuremberg laws. These terrible laws were supported by extrajudicial terror and a permanent state of exception, and we have seen how that played together in the Night of the Long Knives. But the most important instrument, in my opinion, in destroying liberal democracy was the people. People committed to the new ideas of Führervolk and Fatherland, people who were loyal to the new system, who believed in its values, and who were willing to apply a new methodology of legal interpretation. And this, I think, is perhaps the most important lesson to be learned. It was not the law or the rule of law that failed in Germany in the 1930s. It was not democracy or the idea of human rights, but the people. It was people that failed, and it was people that were willing to serve for the national dictatorship. And this is a rather problematic assertion because it implies that democracy or the rule of law, that human rights today are just as strong or weak as they were back then. They stand and fall with people who believe in them and who are willing to defend them in times of crisis, economic or otherwise. And if they don't, we can look to history and see what happened. We all know the rest of the story. The Nazis' blood and soil ideology ultimately led to the Holocaust and to World War II. It wiped out 2/3 of Europe's Jewish population, and an estimated 65 million people died during World War II. For Germany, the total war ended in a total defeat and in an unconditional surrender. Germany lost 5.5 million of its people and its eastern territories. Around 10 million people had to flee from the old East to the new German heartlands. However, Germany didn't cease to exist, leaving us and leaving the Allies in 1945 with the question what to do with the perpetrators. Hannah Arendt pinpointed these problems in a letter to Karl Jaspers she wrote in 1946. These crimes can no longer be grasped legally, she wrote, and that is precisely what makes them so monstrous. There is no adequate punishment for these crimes. Hanging is necessary, but completely inadequate. What Hannah Arendt clearly had in mind in the day were the series of Allied war crime tribunals that the Allies held after World War II, for example, the Nuremberg trials. These trials, however, were trials that were tackling the question of individual responsibility, of guilt, of criminal guilt. But what to do with Germany as a whole and with the German people? What to do with an entire population that had supported a brutal and inhuman dictatorship? The aim of the Allies was quite clear. Their goal was to create lasting peace in Europe and to eliminate Germany as an aggressor. But how? Henry Morgenthau in the 1940s suggested the only way to secure lasting peace in Europe is an industrial disarmament of Germany. He wanted to eliminate Germany's ability to wage war by eliminating its key industries. George Marshall, on the other hand, favored an economic reconstruction over this industrial disarmament, referring to Western Europe as a geopolitical unit with Germany as its core. He envisioned West Germany as a bastion, as a bulwark against communism. In the West, as you all know, the American Marshall Plan was ultimately adopted with this option for open markets and free trade, and thus the Cold War cast its shadow on Germany, and the economical division of Germany was already prepared. The Second World War had united the Allies against Hitler, but soon after the Second World War ended, Europe fell apart again. Germany was initially divided into 4 occupation zones and soon disintegrated into 2 independent countries, the Federal Republic of West Germany and the East German Democratic Republic, or GDR. Both German parts drew different lessons from the Nazi past. In West Germany, history of the West as a whole was told as a tragedy. Political hubris had led man into a moral abyss, and the answer to the National Socialist abuse of power was a return to classic values, a renaissance of the natural law doctrine, and an unprecedented revaluation of the law of the rule of laws. The disasters of the 20th century were not understood as something actual people did, but rather as a crisis of modern ideas of democracy, for example, and an idealistic renewal seen as the solution to that ideological crisis. That is why most Nazis could keep on with their jobs and professions in West Germany as judges, as professors, for example. The West German Constitution of 1949 and the subsequent Federal Constitutional Court Act established a constitutional court based on the idea of the very rule of law, and it created one of the most powerful courts in the world today. Judicial review was institutionalized, and it allowed from now on politics only within the boundaries of the Constitution, or more precisely, only as execution of the Constitution. In East Germany, it was precisely the opposite. History was not seen as a tragedy, but remembered as progress. The emancipation of all humankind had suffered a setback, but not a final setback. Not only had the law not prevented Hitler, but it had enabled Hitler in the first place. For East German intellectuals, the case was quite clear. The fact that the National Socialists could utilize the law with such ease was a verdict against against the law in general. The fact that the old personnel had supported the Nazis or were Nazis all along meant that these people had to be put on trial. The old institutions, the old law had failed, and that meant that the law was to wither away together with the capitalist class antagonism. The rule of law was to be replaced by the rule of the people, however, channeled by an all-knowing and almighty party. Unfortunately, we don't have time here to trace the East German example any further. It's super interesting to see how its models and modes of conflict resolution worked, but unfortunately we have to save that one for class. But rest assured, the law played an equal important role for the rebuilding of Eastern Europe after the war, and it played a huge and important role for the integration of West and East Germany into their respective blocs. After the smoke began to clear, West Germany quickly resumed diplomatic relationships with its Western neighbors and started negotiating the European future. Commonly, the birth of Europe as a political entity is attributed to Robert Schuman, seen here on a picture. Robert Schuman was a French-German lawyer and foreign minister of France, and he laid the groundwork for what was soon to become the European Community in his famous Schuman Declaration, in the famous Schuman Plan of May 9th, 1950. Schumann's reasoning was simple. The pooling of the coal and steel production, which had long been devoted to the manufacturing of guns, of tanks, of ammunition, would make a war between Germany and France highly unlikely, if not altogether impossible. He declared that Europe will not be made all at once or according to a single plan. It will be built through concrete achievements, which will first create a de facto solidarity. Of course, what he had in mind was trade and trade relationships. It was on the basis of this de facto solidarity that France, Italy, Germany, and the Benelux countries signed the Treaty of Paris in 1951, establishing the European Community for Coal and Steel. For the first time in history, 6 states agreed to work together towards the common goal of European integration. Now, make no mistake, The purpose of the Schuman Plan was idealist, to bind France and Germany together so that war between them would never recur. But the means were materialist, to establish a common market based on 4 freedoms of movement, of goods, persons, capital, and services. In short, a free market. 6 years later, Western Europe moved even closer together. The 1957 Treaty of Rome established the European Economic Community and the European Atomic Energy Community with the explicit goal to promote a harmonious development of economic activities, a continuous and balanced expansion, and increased stability and accelerated rising of the standard of living and closer relations between its member states. In other words, peace and prosperity were the European promise since the 1950s. Since then, Europe has come a long way. The Iron Curtain was lifted in 1989, and large parts of the former Eastern Bloc have subsequently been integrated into what was now called a European Union. The European Union was no longer merely an economic community, but a union of values. It typified itself as a union of values, and it wanted its present and future members to subscribe to fundamental principles such as the respect for human dignity, to freedom, democracy, equality, the rule of law, or respect for human rights. It is easy to see that all of these values originate from the European Enlightenment, and that the European Union has adopted these values from history. It presents itself as an answer to the catastrophes of the 20th century. It ascribed to very old ideas, human rights for example, in the light of a terrible new experience, the age of extremes. It is very important to underline that the European project has been successful in securing peace and prosperity in most parts of Europe. However, it is equally imperative to remember that the status quo is not the end of history, and that the promise of freedom, equality, solidarity, justice, and liberty is by no means fulfilled everywhere in Europe or everywhere equally. In Hungary, for example, threatening tendencies to dissolve the system of checks and balances and install an autocratic government have been evident for years. Sadly, the same goes for Poland now, once paragon of the constitutional state. Italy and Greece, which were hit hardest by the 2009 financial crisis, are now largely left alone with the disastrous humanitarian effects of the so-called refugee crisis. People are dying on the borders of Europe and live in disgraceful and inhuman conditions in camps at the European borders. Bulgaria, the poorest country in the European Union, still suffers from massive corruption and has slipped from the 38th to the 111th place on the World Press Freedom Index, not despite, but precisely because it had joined the European Union in 2007. The average per capita income in Bulgaria is only $600 per month, and it is in the same European Union as Germany, where people make five times that money. Germany is greatly profiting, of course, from the weakness of its eastern neighbors and is keeping an upper hand in European policies. Cynics even go so far and claim that Germany has never been so close to European domination. All of this shows that the law that has brought and kept Europe's people together and safeguarded peace and prosperity for centuries is currently under a lot of pressure. We are at crossroads, faced with economical and ecological problems. Governments need to impose strict measures to contain the spread of the global pandemic and the disastrous effects of climate change. However, there is a tendency to weaken parliaments and to criminalize grassroots movement in the name of effective or even scientific measures, to strengthen the executive, the military, or the courts. How can we face the challenges that we are presented right now without endangering democracy? That is one of the biggest and most pressing issues of our time, because we may come to terms with our past, but we still have to act and shape the future one way or another. If there is one lesson that can be drawn from Europe's past, from the 20th and earliest 21st century, it is this: that there is no sudden end to history, that everything achieved is always at stake, and that democracy is fragile, that the law does not protect against tyranny, and dictators use the law just as democracies do. To study how democracies fail, what the alternatives look like, and how law, history, and legal history can be instrumental to understand what's going on, but also how they can be instrumentalized by the wrong people, might help us to understand who we are, where we are right now, and what future we want to live in. I invite you to come to Berlin and discuss these and other issues with me, and I'm more than excited to hear your opinion on all of these topics. Thank you for listening. My name is Max Wagner. See you all in Berlin.
We hope you've enjoyed this week's lecture. You can find the dates and descriptions for all sessions in our digital lecture series, as well as information about our instructors and their courses on our website. Also, connect with us on social media and attend one of our informational webinars. Thank you very much for watching, and we hope to see you again soon, online or on-site here in Berlin.